I had another case that involved the trespasser licensee question we talked about. It was actually against a railroad, and my client was on the back of an ATV, and uh, her friend who was driving it was riding alongside a railroad in like a dirt road, partially graveled, like dirt pathway that goes alongside the railroad. And it was within the railroad's property. When the railroad comes in, they lay some railroad. They don't just control that railroad. They have a certain amount of feet to the right and to the left. They take an easement. So so the railroad tracks, and then certain distance on both sides comes within the control of the railroad. So they're riding the ATV, and it was at night, and there was just a big pile of rocks, gravel that was left in that pathway, in that roadway alongside the railroad that the kid didn't see that was driving, slammed into it. She flew off the back and hit her head on either the tracks or a rock or something. She had pretty bad head injury, and the railroad was pretty certain that that they were trespassers, and so they were going to get out of the case. But I was able to get enough evidence from other people that was regularly used, this roadway along the railroad tracks, by people in the community that ride ATVs and quads and walk and ride bikes, that there was awareness by the railroad. And the argument is to the implicit consent, that I was able to get the case far along enough to, get a, a resolution for my client.